All right. Um, Today is another day. My name is Possible, and I'll be your tutor for today. Today we are going to learn land law. Land law. Make sure to get for yourself your Land Act 2020 Act 1036, because whatsoever we are going to do it from here. In our previous discussion, we began with the introductory aspects of the land law, of which we defined land. We look at the statutory definition, and then we also look at biblical perspective, and then what other learned authors have said about land. Today we are going to look at interest in land. Interest in land. Interest in land. Then once again, I'm going to be your tutor, and my name is Possible. Now, we have interest in land. When you talk about interest in land, land is a property. Don't forget, from our previous discussion, lesson 1, we got to know that land is immovable property. So land is an immovable property that has a lot of interest. It has a lot of interest. When you talk about interest, for the purpose of our discussion, section 81 of the Land Act, please, whatsoever I say, make sure to be making references to them. Section 81 calls this interest as registrable interest. Registrable interest. They are the interest that could be registered. Put it at the back of your mind. At the moment we talk about interest in land, your attention should be shifted to section 1 up to section 10. In fact, saying it appropriately, up to section 8, but add section 9 and 10 to it so that you better understand it. Section 1 up to specifically section 8 talks about interest in land. So that is what you're going to do. You can pause the video and then make sure to read this interest or these sessions of the act before you come and then listen to the lesson. By the end of the discussion, you should be able to discuss what allodial title, customary law freehold, and common law freehold as interest in land, what they mean with their relevant authorities. So you should be able to discuss, you should be able to assess, talk about them with their respective authorities. Let us quickly use 10 to 15 seconds to pay respect to our Land Act, which is Land Act 2020 Act 1036. Land Act 2020 Act 1036. We are paying respect to it. All right. Having paid respect to this act, we can set the ball rolling. The reason why we paid respect to this is that throughout ages, there were different laws so far as land is concerned. Until 23rd December, that was the date of assent, the date that the bill on land became a law. Until 23rd December, that a law was being able to promulgated. The Land Act was being promulgated. And then it became the 1036 Act of the Parliament of the Republic of Ghana, entitled Land Act. What is the purpose of this act? The purpose of the Land Act is to revise, number 1, revise, number 2, harmonize, and consolidate the laws on land to ensure sustainable land administration and management, effective and efficient land tenure, and to provide for related matters. The purpose of the act is to revise, harmonize, and consolidate the laws on land to ensure sustainable land administration and management, effective and efficient land tenure, and to provide for related matters. So that is the purpose of the Land Act. That is the purpose of the Land Act. Now we said today we are going to talk about registrable interest in land. And the question is, what are the various registrable interests that can be held in land in Ghana? Now we have qualified it with the term registrable interest. It means that this interest could be registered. So any interest in land that cannot be registered is not a proper interest in land that is enforceable before the law court. The law court is only interested in the interest in land that could be registered. So if that interest that someone is having in land could not be registered, then it means that that interest can never be enforced before the law court. Do not forget this. So registrable interest in land. Registrable interest in land. That is what we are going to discuss. Before then, let us quickly look at section 281. In fact, anytime I quote section 281, you should get to know that we are talking about the interpretation aspects. Interpretation aspects of the Land Act. The interpretation aspect of the Land Act. The interpretation aspect of the Land Act. So section 281 of the Land Act defines land to include the solid surface of the earth, trees, plants, crops, and other vegetation. A part of the earth surface covered by water, any house, building, or structure whatsoever, and any interest or right in, to, or over immovable property. It means that when we talk about land, in fact, land law, it could be categorized into two broad topics. Number one is interest, registrable interest in land. Number two is registrable rights in land. We have interest in land and we have rights in land. Please know the difference. Registrable interest, section 81. I told you to grab your Land Act, section 81. Section 81 says, section 81 is titled registrable interest. The interest in land which are registrable includes, sorry, it is raining here. So forget about the background. So, registrable interest, the interest in land which are registrable include, section 81, include Allodial title, A, Allodial title, B, common law freehold, C, customary law freehold, D, usufructuary interest, E, leasehold interest, and F, customary tenancy. 6 registrable interests. Section 82 talks about registrable rights, to include the rights that are registrable in relation to land under this act are a mortgage, B, an easement, C, a restrictive covenant, D, profit or prender, E, power of attorney, F, contractual licenses, and G, a user right under a certificate of allocation. 7 registrable rights. Please understand. So what are registrable rights and what are registrable interests? So by the end of the study of land law, you should get to know. So land law is about this. Having treated all the registrable interests, treated all the registrable rights, then you get to know that you have learned land law. I hope you are getting it. So quickly, we are going to focus on the registrable interest. So what are interests in land? According to section 281, the interpretation aspect. Interest in land means any right or interest in or over land which is registrable, So it means that this interest must be registrable. If someone is claiming that he is an owner of a particular land of which that person is not having any registrable interest, then the law can by no means protect such person. The law can by no means protect such person. So understand it once and for all. Understand it once and for all. So like I said, there are a lot of interest in land. A lot of interest. So when you say, I am the owner of this land, it's not all. It goes beyond what we are talking about. So far as Ghanaian law is concerned, there are 6 interests that can be held in land, and then 7 rights that are recognized by the Land Act. These interests are registered under the Act as registrable interest. So you can't just say the land belongs to me. Oh, this land is mine. This land is mine. This land is mine. It goes beyond just saying this land is mine. So you should understand. Now, quickly, we are going back to section 1. Section 1 reads. So section 1, the title of section 1 is interest in land. The following are the interests in land. A. Allodial title. B. Common law freehold. C. Customary law freehold. D. Usufructuary interest. E. Leasehold interest. And F. Customary tenancy. So section 1 of the Land Law or the Land Act. Section 1 of the Land Act is what I just read. It is talking about all this. Section 1. So it is easy if you want to get to understand this. Section 1 lists these items. Then section 2, from section 2 going, it start picking them one after the other. Section 2 is for allodial title. Section 3 is for common law freehold. Section 4 is for customary law freehold. Section 5 is for usufructuary interest. Section 6 is for leasehold interest. Section 7 is for customary tenancy. So you should understand this like this. It moves like this. I hope it makes sense. Section 5 is usufructuary interest. Section 4 is common law freehold. Section 3 is customary law freehold. Section 2 is allodial title. Section 6 is leasehold interest. Section 7 is customary tenancy. So understand it. So quickly, for the purpose of your understanding, I decided to do some acronyms or abbreviations for you, so that you'll be able to make reference to them in order to record them easily. So this is the abbreviation I did. I have what is called ACCOLC. So you can say ACCOLC. A stands for Allodial title, which is section 2. So anytime you're talking about allodial title, come to section 2. Remember, section 1 lists these items. Section 2 start talking about them one after the other. So section 2 talks about allodial title. Then we come to customary law freehold. We come to common law freehold. We come to usufructuary interest. We come to leasehold interest. Customary tenancy. So C, the first C, talks about customary law freehold. ACCOLC. ACCULC. The first C talks about customary law freehold, section 3. The second C talks about common law freehold, section 4. U talks about usufructuary interest, section 5. L talks about leasehold interest, section 6. And then the last C talks about customary tenancy, section 7. So at the moment you're able to write a calc down, you are good to go. Section 2, section 3, section 4, section 5, section 6, section 7. Section 1 lists all of this. Agreed? So I think that is good to go. Let us quickly look at section 81. I have already read it to your hearing. So you can also go there and then read it for yourself. Section 81. Now section 81, let me look at subsection 2. Subsection 2 talks about, for the purpose of this section, section 2 says that an interest in a condominium, an apartment, or a flat shall be registered in accordance with regulations made under this act. It means that the Land Act has even made it possible for us to register our apartment. Possibly there is a building somewhere, a 3-story building, of which you want the last floor. The Land Act 2020 at 1036 has made it possible. It has made it possible for you to register that apartment, though the entire building doesn't belong to you. The entire building doesn't belong to you. Possibly the land belongs to someone. The building also belongs to someone. And then now you are coming for the apartment, or you are coming for a flat, or you are coming for a floor. The land law, the Land Act 2020 at 1036 has made it possible. It has made it so clear to understand that now we can register a flat, apartment, or a condominium. A condominium. So that is how it is. Understand it. So section 82 talks about the rights. Section 82, that is what I've projected. Section 81, subsection 2, condominium. That is what I read. Now, section 82 talks about the rights, the 7 rights that have been recognized under the Land Act 2020 and 1036 in relation to land have been captured under section 82 of the Act. Section 82 of the Act. And it reads as follows. I think I've read them for your hearing. So look at them for yourself. So now look at them for yourself. Look at them. We have mortgage, an easement, a restricted covenant, profit or prender, profit apprender, power of attorney, a contractual license, and a user rights and a certificate of allocation. Now, we are going to shift our focus and our attention from registrable right in land, and then move it to registrable interest in land. 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 So, are you ready? Are you ready? Are you ready? Section 81, as we read, what talks about registrable interest. Registrable interest. ACALC. Using the ACALC. ACALC. Section 81. We have seen that these listed points are the registrable interest in land. For the purpose of our discussion, we are going to treat them one after the other. One after the other. So let us quickly pick number 1, the one in red. Allodial title. What is this allodial title about? When you talk about allodial title, what does it mean? Allodial title. What is this allodial title about? What is it about? Allodial title. When you talk about allodial title, it is the ultimate and highest interest held in land in Ghana. It means that when you're talking about allodial title, that is the highest and the ultimate interest that is held in land in Ghana. Highest. For the purpose of our discussion, I will be talking about some vernacular words or vernacular names, which is local names, or I will be using local terms. So understand it that way, because we are talking about land law in Ghana. So when you talk about allodial title holders, they are the ultimate and the highest interest held in land. Benchi and Enchel even said that they are the supreme. So don't forget this. Section 2 of the Land Act 2020 at 1036 defines the allodial title as follows. So now open your Land Act to section 2. I have my own in front of me. Open to section 2. Section 2, title, allodial title. Allodial title. Allodial title is the highest or ultimate interest in land. B, held by the state or stool or skin or clan or family or an individual. It means that the location of the allodial title is number 1 in the state, according to Article 4. According to Article 4, which is Chapter 2 of the 1992 Constitution of the Republic of Ghana. It talks about territories of Ghana. Article 4, Clause 1. The sovereign state of Ghana is a unitary republic consisting of those territories comprised in the religion which immediately before the coming into force of this constitution existed in Ghana, include the territorial sea and the air space. Parliament may by law provide for the delimitation of the territorial sea, the contiguous zone, the exclusive economic zone, and the continental shelf of Ghana. So that is how it is. So it means that the state also could be allodial title holders of a land. Allodial title holders of a land. And then we have a stool or a skin. A stool for the Ashanti or for the Akans, and then a skin for the Northerners. A stool and then a skin. Let's continue with this section 2B. It continues, and may have been acquired through compulsory acquisition, conquest, pioneer discovery and settlement, gift, purchase or agreement. What are we talking about? We are talking about ways of which allodial title could be acquired, ways of which we could become allodial title, or ways of which someone could become allodial title, or ways at which someone became allodial title. And we are saying that and have been acquired through compulsory acquisition. So there could be a compulsory acquisition, the situation whereby the state wants to construct a road and then someone's building is there or someone's land is there. The nation, for the purpose of the larger benefit to the citizens of Ghana, the state could acquire compulsorily, could acquire your land or could seize it. However, the Land Act provides the procedures and the compensation that must be given out. So we are not diving into it. But what we are trying to say is that though it might be against your will, but the state will have that right to take that property, to acquire the land, to acquire it and use it for the benefit of the state. So we have compulsory acquisition. That one is against voluntary. So it is involuntary. And then we have conquest. In the olden days, people used to go for war. When you go for war and you are able to defeat them, the defeated ethnic groups becomes your subject. They become your slave, and automatically their land becomes yours. So by conquest. The next one is pioneer discovery and settlement. In the olden days, our great grandparents most of them were palm wine tappers, most of them were farmers, most of them were hunters. So in the course of their daily work, if they discover a land of which no one is living on it, then what they do is to settle on it and later on move their family members to that particular land. We have gifts. The gift could be a Allodial title holder handing over his Allodial title to another clan. So a stool can gift a land to another stool, so as a stool can gift a land to a family. A stool could also gift a land to an individual. So we have gift, we have purchase. Someone could also purchase it. So that is how it is. And then agreement. Now let us look at what Benchi Enchel, what he said about Allodial title. The Allodial title has been described by some scholars like Benchi Enchel as the supreme, absolute, and ultimate title. So Allodial title is the supreme, absolute, and the ultimate title in land. The supreme, absolute, and ultimate title. It is always in either the state, in the hands of the state, the stool, the skin, a clan or family, or an individual. Yes. So when you go to Asante Kingdom, we have paramount chiefs, and then we have the king. So the king could be, or the king is the Allodial title holder, but he's not the king himself, because the king is serving a stool. The Asantes are not paying allegiance to the king. They are paying allegiance to the stool. So the stool is the Allodial title holder. It means that the king cannot claim the ownership of the land. It belongs to the stool. The king cannot claim the ownership of the land. When he moves out of office or he is dead, he cannot transfer it to his children. It belongs to the stool. So that is how it is. We should understand this. We should understand this simple explanation. So that is the Allodial title is the main source or root of title in Ghana, except in few special cases. Yes, we can have individuals who are also Allodial title holders. Individuals, but they are very rare. It doesn't mean we don't have. We have. So that is how it is. So you should understand it. We look at some case, Dennis and Atta versus Ababio. We look at that one, and then from there we analyze cases. So that is how it is. So we are saying one such special case is what have been enshrined or noted in the memorandum. Sorry, like I told you, it is raining here. So sorry for the background. So one such special case is what have been enshrined or noted in the memorandum to the Land Title Registration Law, 1986 PNDC law. PNDC is Provisional National Defense Council Law. Provisional National Defense Council Law 152, and which has one of the primary concerns of the passage of PNDCL 152. This gave recognition to the fact that an Allodial title owner may make a gift of his Allodial title to an individual. Yes, I think I've said it. A stool that is Allodial title holder could gift a portion of land to someone. Possibly the person has done something so good for the society, and then the society says, go and take this plot, go and take this land. So that one is there. So you should understand it. Now let us look at the exceptions. We are saying that Allodial title holders, mostly their clans, their family, their skin, and then their stool. However, there is a special case of Dennis and Atta versus Ababio, 1941. Cape Coast Divisional Court. In fact, it is in the olden days, so Divisional Court of Cape Coast. In this case, a land was being taken from the Allodial title holders and used to settle a particular debt. So that was the decision of the court. So let us look at the case. In the case of Dennis and Atta versus Abbeville, 1941 Divisional Court of Cape Coast, a stool land was taken in execution of judgment debt against the stool. So because the stool land belongs to you, does not mean you can't lose it. You can lose it. You can lose the stool land. So beware. Beware. That is how it is. It was held that the purchaser, at a subsequent auction sale of the land, acquired the right title and interest of the stool, which could only be allodial title. This also became one exception to the conventional position that the allodial title is vested in one stool or skins. So understand it, that individual, in the case of Dennis and Atta versus Abbeville, a particular land was taken from the defendant. A particular land was being taken away from a family, and it was being given to an individual person. Now my next question is, yes, you have seen allodial title, but this allodial title, could we buy it? Could this allodial title be acquired? But before then, make good use of these cases. Make good use of these cases. Make good use of these cases. So that is how it is. That is how it is. Now, could this allodial title, could it be acquired? Could it be acquired? All right, we'll get to know that. But before then, let us analyze the exceptions to the allodial title. We have looked at Dennis and Atta versus Abbeville. Cases supporting this are Go Lightly versus Asrifi, and then Edu versus Ajay. Edu versus Ajay. All right, Edu versus Ajay. Understand it. So far, how far? So we have seen that individuals exception. Yes, we said that allodial title holders are mostly stools or skins or the states. And then one exception was being seen in the case of Dennis. In the case of Dennis and Atta versus Abbeville, 1941, Divisional Court of Cape Coast. It was being seen here. And then another exception is whereby a family or a clan is also holding allodial title or allodial interest in land. So when you look at most parts of Ewe lands, or the Greater Accra region, you will see that most, or let me say some of the areas belong to families. It is indeed quite rare for an individual to hold the allodial title interest in land nowadays. However, in some traditional communities in Ghana, the allodial title is vested in families, clans, as well as individuals. So the fact that it is rare for an individual to hold the allodial title does not mean we don't have some. Just that they are very rare, very, very uncommon. I hope you are getting it. Good. So allodial title, what is allodial title? Allodial title, we are talking about the supreme interest, like the party that is, let me say, the big body or the big, I'm taking it out of legal terms. Let me say, the person or the institution who is the overall owner of land. Overall owner of land. A particular land. So, if I'm having a land, it could be that my land, the land that I'm having, I rented it from someone. Yes, it is mine because I've rented it. But it is not mine because it belongs to someone too. And possibly that person too also took it from his mother. So you see that land, there are several interests in land. Several interests in land. So that is what we are analyzing. But the allodial title, it is the major, the omega, last title. So when you say that someone is allodial title holder of a land, it means that beyond the person, there is no one. Then it is God. Then it's God. I hope you are getting it. So that is how it is. Now, within the scope of the exceptions, let us analyze the case of Srasreku versus Okine, 1930. Srasreku versus Okine, 1930, West Africa Court of Appeal, page 49. So, the Court of Appeal held, in the case of Srasreku versus Okine, that a stool might sell land to a stranger, retaining nothing more than a remote chance of reversion if the purchaser died without succession. I repeat myself. It was held that a stool might sell land to a stranger, retaining nothing more than a remote chance of reversion if the purchaser died without succession. So, allodial title is something else. Principle number 1. In the case of Srasreku versus Okine, 1930, it says that when an allodial title holder, let me say in this case the Asante king, possibly sells a land to a stranger, someone who is from northern region or someone who is from outside Asante region, right? A stranger, someone, and then he sells the land to him. If that person dies and then there is no successor to that person, automatically the land becomes the land reverses. It comes back to the allodial title holder who initially sold it out. So in this case, the land comes back to the Asante king. If a paramount chief sells a land, possibly some people traveled and then they were strangers and then they came, and then a particular paramount chief sold the land to those strangers. Right? Nice one. So if that person dies without a successor, the land must come back. It must come back to the allodial title holder. In this case, the paramount chief. So understand the principle, one principle. You should be able to use Srasreku versus Okine, 1930. Or Srasreku versus Okine. That's all. Srasreku versus Okine. The principle is that when a allodial title holder sells the land to an individual, and then the individual dies without a successor, the land comes back. The land becomes the property of the initial allodial title holder who sold it out. So that is how it is. Now the question is, allodial title, which is the omega to land, could it be acquired? Could it be acquired? The answer is yes. I wouldn't even let you contemplate. The answer is yes, because we read from section 2. Section 2 says that and may have been acquired through compulsory acquisition. All these ones I've explained them, so I think here we are going to speed. We are going to speed up. And may have been acquired through compulsory acquisition, conquest, pioneer discovery, and settlement, gift, purchase, or agreement. Don't forget, I told you that compulsory acquisition is involuntary. It is against the person's will. Conquest is against the person's will. Right? So, when you are classifying, when you're grouping this acquisition mode by their voluntary and involuntary, then compulsory acquisition is involuntary, and then conquest is involuntary. If you are grouping them to modern and the old, when we reach there, we'll talk about it. So how is the allodial title acquired? One of the locus classicus case, so far as the land law is concerned, don't forget this. Don't forget this case. If you don't know anything, don't forget this case. The case of Ohemen versus Ejin. Ohemen versus Ejin. Ohemen versus Ejin. Ohemen, Ohimen. Ohimen. Ejin. Adjei. Ejin. Adjei. Ejin. Ohemen versus Ejin. Never forget this case. Locus classicus case. The mode of creation or original acquisition of the Allodial title has been described in Ohemen versus Ejin as discovery by hunters or pioneers of the stool of unoccupied land, settlement thereon and use thereof by the stool subjects. It also identifies conquest, purchase, and gift as modes of acquisition of the Allodial title. In that case, the case of Ohemen versus Ejin. If that be the case, then let us shift almost 5 minutes of our attention on the case of Ohemen versus Ejin, where 4 principal methods by which a stool could acquire a land, or by which a land could be acquired, was being outlined. So, shifting our attention to the case of Ohemen versus Ejin, there are 4 principal methods by which a stool acquired land. 4 principal. They are conquest and subsequent settlement thereon, and cultivation by subjects of the stool. That is 1. It means that if a particular ethnic groups, if they are strong enough, they can conquer another ethnic group, and then when they conquer them, they become their subjects, and automatically their land becomes their own. Number 2, discovery by hunters or pioneers of the stool of unoccupied land and subsequent settlement and use thereof by the stool and its subjects. It means that in the olden days, hunters, when they are moving around, or pioneers or farmers or palm wine tappers, when they are moving around and then they find a land of which no one is settling on it, then they become pioneer discoverers. And then number 3, gifts to the stool. So one stool can gift a land to another stool. One stool can gift a land to a family. One stool can gift a land to an individual. And then the last one, according to the case of Ohemen versus Ejin, is purchased by the stool. Purchased by the stool. Purchased. In fact, you need not worry yourself about this, because section 2 is extensive. You could see that section, all these ones indicate, the ones that have been mentioned in the case of Ohemen versus Ejin, all of them are stipulated under section 2. Under section 2. Under section 2. So you need not to worry yourself. All of them are stipulated under section 2. Under section 2. So you need not to worry about this. You need not to worry about this. You need not to worry about this. So quickly, for the purpose of our discussion, we are moving on. Now, Ohemen versus Ejin, continuation. Ohemen versus Ejin. In Ohemen versus Ejin, the stool, without reference to a subject family who had acquired possessory title to an area of the stool land, purported to lease a portion of that land to a stranger for the erection of a cinema. The family thereupon sued the stool for declaration of their title and for an injunction, and they succeeded against the stool. That is the case. The stool, without reference to a subject family, you are a stool. And the stool is not a stool alone on its own. Every stool has subject. Subject. When you go to Asante Kingdom, a stool has a subject. When you go to Asante Kingdom, a stool has what? Has subject. So if you're a stool and you have subject, and then you the stool, probably the king. When we are talking about stool, it doesn't mean a chair. The stool, specifically in law, we normally refer to the king. The king. But it doesn't mean that it belongs to the king. It belongs to the stool. So it means that when the king lives there, The next person who will come also will come and continue. So that's the stool. So a stool, the land belongs to all of us, the whole family. And then you want to sell the land out to someone. And then a particular family said, no, we are not going to buy into this idea. It belongs to all of us. The stool belongs to all of us. We all are paying allegiance to this stool. So you can't just sell it. Then give us our portion. Give us our portion. Family dear mommy, you family dear mommy. That is the case of Ohimi versus AJ. So that is how it is. The stool without reference to a subject family who had acquired possessory title to an area of the stool land. Because we are part of the stool, we have a portion that we are staying or we are reading or we are farming, or a portion that our house or our building is. And then you go ahead to lease a portion of that land to a stranger for the erection of a cinema. So the family, that was what made the family brought the entire issue to the law court. So what was the holding of the court? The court held that the stool holds the absolute title in the land as trustee. The word is trustee. Trustee is underlined. Trustee for and on behalf of a subject. So if a stool, a king, a chief, a paramount chief, whatsoever, and then you are holding a land in trustee for, in trust, you are a trustee. You are holding a land. You are a trustee. So you are holding it in trust for and on behalf of those people who are under you. So the land doesn't belong to you. The fact that you are a king doesn't mean you can use the land for anything. No. You are a trustee. So if you are misbehaving, if you are selling the land not in accordance with the traditional principles or the customary principles, then your subject could raise arguments against that. So that is how it is. And the subject are entitled to the beneficial interest or usufruct thereof and have to serve the stool. So the subjects are serving you. So they are entitled to their portion. Usufruct. We learn this usufructuary interest. You get to know that. Over there, we analyze this case again. So each individual or family is regarded in the broad sense as the owner. So each family A, family B, family C, who are occupying the stool land, they are also regarded in the broad sense as the owner of so much of the land as it is able by its industry or by the industry of its ancestors to reduce into possession and control. Let me explain here. To reduce into possession. That means the land was originally, it was bushy. The land probably it was forest. Probably the land was abandoned area. And then they were able to reduce it. Pull down all trees, clear the land, build their houses, do their farm. And now you are come to say that you are come to take it from them. No. As long as they pay allegiance, as long as they pay allegiance, they save the stool. They save the stool, you cannot take it away from them. It means that if they deny, if they renounce their allegiance to the stool, then the land could be taken away from them. But as long as they save the stool, they pay allegiance to the stool, you can't take the land from them. So understand it. You understand it very well under usufructuary interest. When you reach usufructuary interest. Here I'm just trying to analyze the case for you to understand the case. All right. Let's continue with the holding. The area of land so reduced. Please, I want you to understand the reduced. Reduced means that you have cleared it and you are using it. You have cleared it.